All right, so I will call this meeting to order. The regular meeting of the Civil Service Commission for April 2nd, 2025 will now come to order. I have a gavel, but I will not slam it. Welcome in person and online attendees. If you would like to provide oral comments on any of the agenda items, please be sure to use the instructions on the first page of the agenda. If you are attending this meeting in person, you would like to pull an agenda item for discussion, when asked, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. Attendees joining this meeting using the Zoom application will alert commission staff of your intention to speak about the agenda item by using the Q&A function at the bottom of the screen. Please include your name, telephone number, and other identifying feature you selected when logging in, and the agenda item you wish to speak about. Attendees who dialed into today's meeting, please press star 9 on your telephone to raise your hand and alert commission staff of your intention to speak about an agenda item. When called upon for you to speak, please unmute yourself using the star 6 button on your phone. We will now commence the order of business. Will the commission secretary please take the roll?
Commissioner Coleman, Commissioner Fletcher,
Present.
Commissioner Johnson,
Present.
Commissioner Rodriguez Kennedy.
Present. All right, that leads us to item B, which is the approval of the minutes. May I have a motion to approve the minutes of the regular meeting of the February 5th, 2025?
Commissioner Johnson moves to approve.
Okay, there's a motion by Commissioner Johnson to approve. Is there a second?
Commissioner Fletcher seconds.
There's a second by Commissioner Fletcher. We will now move to a vote. Commission Secretary, please record the votes.
Commissioner Fletcher,
Aye.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy.
Aye, and that carries with all Commissioner Coleman absent and all commissioners present in favor. We'll now move to non-agenda public comment. Members of the public may address any matter relating to the Civil Service Commission other than items that are on today's agenda. The total amount of time for people allowed for public comment will be limited to not more than 2 minutes unless the commission president agrees to extend the time. Do any of the attendees would want to make a public comment about any matter relating to the Civil Service Commission, but that is not on today's agenda? If so, and you are joining the meetings using Zoom, please use the Q&A function at the bottom portion of your screen to inform commission staff. If you dialed in today's meeting, please use the star 9 button on your telephone number or on your telephone to raise your hand to alert commission staff. When you're called upon for you to speak, please unmute yourself using the star 6 on your telephone. We will need to wait a minute in the event somebody wants to make a comment and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
Commissioners, 1 minute has passed and we've received no request to make a public comment.
Hearing none, we will move on to the agenda item. Wait, am I right?
Yep.
Okay. Agenda item discussion. Do any attendees want to pool an agenda for discussion? If you are attending in person, please stand and identify yourself by name or number, and we will return your item to your item after the consent agenda is approved. If you're speaking for an appellant or complainant, please use their assigned number. If you join the meeting using Zoom, please use the Q&A function on the bottom portion of your screen to inform commission staff of the agenda item you want to speak about. If you dialed into today's meeting, you may press star 9 on your telephone to raise your hand to alert commission staff. When called upon to speak, please unmute yourself using the star 6 on your phone. We will wait a minute in the event somebody wants to pull an agenda item and is attempting to alert staff now. Will the commission executive officer please start a timer?
Yes. Commissioners, 1 minute has passed and we've received no request to pull an item for discussion.
All right. Will the commission secretary please announce the items forming the consent agenda?
Commissioners, agenda items 7 and 8 are automatically pulled for discussion. Agenda item 10 has been taken off the agenda and pulled by the appellant for discussion.
No.
Nope, agenda item has been pulled for discussion by the appellant. Agenda item 10 has been taken off the agenda and placed on the May 7th agenda. Therefore, agenda items are 1 through 6 and agenda item 11 form the consent agenda.
And agenda item 9.
Okay. Let's see here. May I have a motion to approve the consent agenda?
Motion to approve the consent agenda.
Motion by,
Commissioner Johnson?
I know, I have.
That's right.
I'm not responding this morning. I don't know what happened. My throat dried up right then.
Just make you speechless.
Hold on. Before you vote,
Oh,
we
there's,
do have
Wait a
a
second.
raised hand.
we don't have a second yet, so let's see that raised hand.
David, can you unmute yourself?
Good afternoon, David Lopez, attorney for item number 2025 TAC 010P. I apologize. I didn't raise my hand within the time limit to be able to pull my agenda for discussion. I was
So
hoping.
you're wanting to pull, is it agenda item number 9?
Yes,
Okay, we will pull that. So that amends. So David, you can mute yourself for the next few minutes while we take care of items 7 and 8.
Right, so now the motion would be to approve the consent agenda, which only has items 7 and 8, or 1 through 6,
6 and 11
and
1 through 6 and 11.
and 11.
1 through 6 and 11?
Yeah, because we're going to do 7 and 8.
Oh, they have to do individual. You're
We're
right.
talking 9 and then 10 is taken off the agenda.
So could you repeat the for the record?
Commissioners, agenda items 7, 8 were automatically pulled for discussion. Agenda 9 has been pulled for discussion by appellant. Agenda item 10 has been taken off this agenda and placed on the May 7th agenda. Therefore, agenda items today are 1 through 6 and number 11 form the consent agenda.
All right, we're all on the same page now. Is there a motion?
I move to approve.
Is there a second?
A second.
All right. Will the commission secretary please record commissioner votes?
Commissioner Fletcher,
Aye.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy,
Excuse me. Aye. Sorry. All right. Now we will move on to our discussion items. Item 7, which is Commissioner Fletcher's report on a disciplinary hearing. Do any of the attendees which want to speak about this agenda item? If so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen to alert commission staff. If you dialed into today's meeting, you may use *9 to raise your hand to alert commission staff. When we will need a moment we will need a minute in the event that somebody wants to speak about this item and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
One of these days, I'm gonna have this memorized.
Commissioners, 1 minute has passed and we've received no request to speak about this agenda item.
Okay. Hearing none, we will, Commissioner Fletcher, if you may proceed with your report.
Thank you, Commission President. Appellant 2024-035 P as in Paul, or referred to as employee, appealed an order of termination and charges removing him from the position of Deputy Sheriff Detentions Court Services in the Sheriff's Office for these purposes labeled Department. The commission appointed me, Commissioner Brian J. Fletcher, to hear the appeal and submit findings, conclusions, and recommendations to the Civil Service Commission. Thereafter, a hearing was held on February 27th and 28th, 2025. The causes of discipline were dishonesty, failure of good behavior, and acts incompatible with and/or inimical to the public service. Findings of fact. Employee had been employed as a Deputy Sheriff Detentions Court Services for approximately 5 years, and he was also designated a field training officer. The employee was assigned to Team 1 on the 7th floor at the San Diego Central Jail, otherwise known as SDCJ. The 7th floor is identified as holding those incarcerated persons who require special treatment due to signs of mental illness or are prone to demonstrate force against the deputy, or both, identified as administrative separations or ADSEPs. On April 10, 2023, during his shift, the employee was training Deputy 1, who was recently promoted to Deputy Sheriff following graduation from the Department's Corrections Academy. Deputy 1 was on approximately the 7th day of his Phase 1 training in corrections. As a Phase 1 deputy, Deputy 1 had only been a Deputy Sheriff in corrections for a period of no more than 12 days. The morning of April 10, 2023, an incarcerated person housed on the 7th floor in Module 7D, otherwise known as Module, was scheduled for a court appearance. The incarcerated person, or we refer to him as IP, resisted efforts to cooperate, and it resulted in an extraction to remove him from the cell 14. At approximately 11:35 a.m., the IP returned from a court appearance and exited the elevator on the 7th floor. He then went to the door to enter the 7th floor and was allowed entry to the floor by Deputy 1 approximately 1 minute later. The employee accompanied Deputy 1 to the door and followed Deputy 1 and the IP as Deputy 1 escorted him toward the module. Both Deputy 1 and the employee were donning light blue latex gloves. During this short period of time, prior to entering the day room of the module, the IP was steadily chirping or chipping at the employee. The employee, Deputy 1, and the IP arrived at the staging door of the module and passed through the door into the day room. After hearing loud talking between the IP and the employee from the time that the IP entered the 7th floor and as they walked to staging door to the module, Deputy 2 joined the group at the staging door as cover deputy and entered the module, joining the employee, Deputy 1, and the IP. While entering the module, the employee accessed non-department issued gloves and put them on over his latex gloves. During this time in the day room, Deputy 1 is controlling the IP with his hand on the IP's back and guides him face forward toward the wall, with the employee and Deputy 2 watching. Deputy 1 bends down to remove the leg shackles from the IP. The leg shackles were removed by Deputy 1, and at the direction of the employee, with the pointing of his right hand as he held the IP's back, Deputy 1 then leaves the module with the shackles. When he returned to the doorway, Deputy 1 receives another direction from the employee with the pointing of his right hand, and Deputy 1 re-enters the module. At that point, Deputy 1 begins to remove the shackles from around the IP's waist. During the period that Deputy 1 is removing the shackles from the IP, the employee has control of the IP by grasping the back collar of his shirt. During the entire period that the employee and the IP are in the module, the IP is repeatedly turning his head from side to side, speaking to the employee, Deputy 1 and Deputy 2. The group then ascends to the stairs to the second floor of the module. The employee has the IP controlled by grasping his left arm. Deputy 1 follows immediately behind them and to the right of the IP. And Deputy 2 follows the three of them on the left side of the stairs. The group arrived at cell 14 and opens the door. The employee, still grasping the IP's left arm, directs him into cell 14 and enters with him, with Deputy 1 following behind them. Deputy 2 remained outside of the cell. Approximately 6 seconds later, the shadow of Deputy 1 disappears from the wall immediately inside the opening to cell 14, and 8 seconds after that, Deputy 2 enters the cell. Deputy 2 exits cell 14 10 seconds later, followed by Deputy 1 3 seconds after Deputy 2. Employee exits the cell 8 seconds later. During the time the employee, Deputy 1 and Deputy 2, are inside the cell 14, another incarcerated person in a cell 3 doors away from cell 14 came to his window and looked out toward cell 14. A second incarcerated person in the 4th cell away from cell 14 came to his window and also looked out. After the employee walked past this second cell, where an incarcerated person was at the window, he stopped, turned back, and paused at that cell door, then walked towards the stairs. Then Deputy 2, followed by Deputy 1, with the employee following them both, descended the stairs to leave the module. In the evening of April 12, 2023, Deputy 1 met with Deputy 3 at a Chipotle restaurant in Temecula. The two had been in a mentoring relationship, which started prior to the Deputy 1's application to the SDSO Detentions Academy. Deputy 3 had previously encouraged Deputy 1 to work toward being a deputy sheriff. The relationship began as a result of Deputy 3's friendship with the father of Deputy 1's girlfriend, and the two of them would meet every 3 to 5 weeks. At their meeting on April 12th, Deputy 3 noticed that something seemed to be troubling Deputy 1 and asked if there was anything wrong. Deputy 1 then described the incident involving the IP, the employee, Deputy 2, and himself on April 10, 2023. It was at that time Deputy 1 first stated to anybody else that he had witnessed the employee use force against the IP when returning him to the cell in Module D. Upon inquiry, Deputy 3 became aware that Deputy 1 had participated in the force used on the IP by entering the cell and grabbing IP's leg for a brief period. He also became aware that no reports of the use of force by the employee and Deputy 1 were made by Deputy 1, and he knew of no reports made by the employee before leaving work early. Deputy 3, as a mandated reporter, then became responsible for reporting their conversation and Deputy 1's failure to report the use of force on the part of the employee, Deputy 1 and Deputy 2. Later that evening, Deputy 3 called an IA sergeant that he knew, leaving a voicemail, then calling his sergeant to discuss what needs to happen. The two of them discuss whether this is something that could be delayed to the next day, but the IA sergeant returned his call that evening, initiating an investigation into the incident. On April 12, 2023, at approximately 9:54 p.m., Deputy 1 received a call from DIU sergeant directing her to speak with the IP at the SDCJ relating to the possible use of force involving the IP that had not been reported. The DIU investigation involved interviews conducted by Detective 1 and Detective 2. They interviewed employee once, Deputy 1 twice, and Deputy 2 once. The same detectives also interviewed the IP at SDCJ once. The statements made by Deputy 1 and the IP in their interviews both confirmed that on April 10, 2023, the employee struck the IP on the back of his head at least 2 or 3 times while the 3 were in or at the door of cell 14. The statements of the employee and Deputy 2 both confirmed that although there was ongoing chirping by IP, including calling the IP the N-word and making inappropriate comments about his mother, the employee did not respond with, or in the case of Deputy 2, he did not observe any use of force against the IP. Following its investigation, the DIU, the incident was handled by Internal Affairs Unit, referred to as IA. IA received the DIU report, and the complaint was assigned to Sergeant 1 of IA for investigation on April 26, 2023. As a part of her investigation, Sergeant 1A conducted additional interviews of the employee, Deputy 1, Deputy 2, and the IP. B, reviewed the materials from the DIU investigation and report. C, reviewed video recordings of activities in the module on April 10, 2023, and D, reviewed and considered such other matters as she deemed necessary to determine whether there was a preponderance of evidence to support a finding that the employee's conduct was in violation of Department Policy and Procedures Sections 2.46 and 2.49. Following such consideration, Sergeant 1 determined that there was a preponderance of evidence to sustain the complaint against the employee. Relatively soon after April 10, 2023, Deputy 1 was transferred to Vista Detention Center, or VDF. Deputy 1 resides in Temecula, and the location of VDF is much closer to his home. Deputy 1 said that VDF was at the top of his wish list for assignments as it is closer to his home, but he did nothing more to initiate or control the transfer. While at VDF, Deputy 1 was investigated for an act of dishonesty when he didn't show up for work on Memorial Day, although he knew he should have been there. Shortly after the investigation into this matter, Deputy 1 was terminated prior to the end of his probation period. The remaining facts to be determined are: 1, whether the employee directed Deputy 1 to remove both the leg chains and waist chains before escorting IP to cell 14. 2, whether the employee aggressively moved IP into cell 14 for the purpose of responding to IP's continued and aggressive comments. 3, whether the employee used force on IP in cell 14 on April 10, 2023, and if so, what force was used. And 4, whether the employee shouted out to other incarcerated persons when he paused and turned around at the top of the stairs that IP is a bitch. Based on the preponderance of evidence presented to the hearing officer, the following facts are found to be true. 1, on April 10, 2023, while serving at the training officer for Deputy 1, the employee communicated to Deputy 1 that he was to remove both the leg chains and the waist chains before escorting IP to the cell. The employee has stated that it is his practice to only remove the leg chains and leave the waist chains on until arriving at an incarcerated person's cell, but that Deputy 1, of his own volition, removed the waist chains too. The employee also stated in his internal affairs interview that he trains his trainees to take the chains off if not agitated, but leave them on if agitated. Deputy 1 has stated that he was surprised by the employee's directions to remove the waist chains at the bottom of the stairs, as he was recently trained at the academy to leave the chains on until reaching the cell, then removing them through the door slot. Assuming that Deputy One was committing an error by removing the chains on his own volition, there is no reasonable excuse. There is no reasonable excuse not stepping in and correcting him, even in front of the IP, when the chains are important for the security and safety of an incarcerated person as well as deputies escorting the incarcerated person. Whether corrections were made in the presence of an incarcerated person should not be a factor. Even Deputy 2 stated that he doesn't practice removing the chains prematurely, again, for the safety of the incarcerated person and the deputies conducting the escort. 2, the preponderance of evidence supports the finding that the employee was aggressive in placing IP into his cell. This aggressive behavior, coupled with the ongoing aggressive chipping between the two of them, was not useful in attempting to calm IP down while they were in the cell. On the contrary, due to the continued aggressive and loud comments exchanged for most of the time the two were together, it is reasonable that it would increase the aggressiveness of IP. Employee's entry into cell 14 was unnecessary and could only serve one of two purposes: either to demonstrate control of IP in its limited space, or to place the employee out of the sight of the many CCTV cameras throughout the module. The employee added another reason for entering an incarcerated person's cell, and that was to look for contraband that the incarcerated person might have left out in plain view, not having the time to hide prohibited items. However, the employee had earlier extracted IP from cell 14 and does not explain how contraband would somehow appear during IP's trip to the courthouse. Setting aside this alternative reason for entering cell 14, it is more likely than not that the employee was intent on being outside of the view of CCTV cameras. 3, the preponderance of the evidence supports the finding that the employee used force against IP while in cell 14. Although the employee argues otherwise, Deputy 1 has consistently stated that very shortly after IP and the employee entered cell 14, the employee struck IP in the head two to three times. IP has consistently stated that he was struck by the employee upon entering cell 14, although he recalls many more than 3 strikes. His testimony at the hearing in this matter was more realistic, although he estimated 8 punches, not 2 or 3. What further supports this finding is that there is no evidence that IP and Deputy 1 had any further contact since April 10th, 2023, and their statements and testimony must consistently assert that the employee used force in cell 14. Number 4, while perhaps less important than the finding that the employee used force against IP, the contemporaneous shout to the module that IP is a bitch is further evidence that the employee was still in a state of anger over the constant barrage of comments from IP that he couldn't control his emotion, even when outside IP is present. The employee has no recollection of shouting the statement, but Deputy 1 has consistently maintained that the expletive was shouted, even before having the benefit of the CCTV video, reflecting the employee's abrupt turnaround and pointing while outside the door of a cell 4 doors away from cell 14. Conclusions. Employee is guilty of dishonesty by failing to respond truthfully to the fullest extent of his knowledge in the DIU investigation and the subsequent IA investigation. Employee is guilty of failure of good behavior by using force when returning IP to cell 14 in the module on April 10th, 2023. Employee is guilty of acts incompatible with and or inimical to the employee service by such conduct, both in the use of unnecessary force and failing to be truthful and forthright to the full extent of his knowledge of the events that transpired on April 10th, 2023. Level of discipline. Based on the years of experience of the employee, including a leadership role in training new deputies, the employee should be well aware of his responsibilities as a San Diego County Sheriff's deputy. On April 10th, 2023, the employee failed to meet his obligations as a training officer of a Phase 1 deputy. His familiarity with the detentions environment, and in particular, the verbal and physical abuse that comes from the ADCEP incarcerated persons, which is frequent and threatening, should have been of tremendous benefit to Deputy 1, who was aspired to be a detentions deputy. Instead, he failed Deputy One and by such failure brought disrepute to his team when others outside of detentions became involved after Deputy One felt he had an obligation to speak out. It is this hearing officer's recommendation not to overturn the sheriff's decision and to sustain the termination of the employee. Recommendations. Based on the findings and conclusions set forth above, I hereby recommend the following decisions. That the order of termination and charges be affirmed, and that the proposed decision shall become effective upon the date of approval by the Civil Service Commission, and I so move.
Thank you, Commissioner Fletcher. Is there a second?
Commissioner Johnson seconds.
Let me make sure I'm on. Yeah, boy. Is there any discussion? Yeah. Well, I will actually just acknowledge that, because we had this situation where something happened. It wasn't caught at the time, but someone else reported it to the proper authority. So, and the command did the right thing. It appears like in this situation, they took action against a deputy who attacked someone in our custody. So I think this is an example where the system worked, and where the sheriff made the right decision in this whole process. So I just wanted to acknowledge that, because sometimes we have to be very critical. But in this case, the situation worked, and Deputy 3 reported it properly when he didn't really. I mean, he wasn't involved in this at all. This could have easily went under the rug or something. But the integrity of Deputy 3 and the command led to and the diligence of our hearing officer led to a just action. So I will move to ask the commission secretary. Wait, is that it? Yep. Ask the commission secretary to record commissioner votes.
Commissioner Fletcher,
Aye.
Commissioner Johnson.
Aye.
Commissioner Rodriguez Kennedy.
And that decision is affirmed by a unanimous vote of the commissioners present, and Commissioner Coleman is absent. Next is agenda item 8, which is also Commissioner Fletcher's report on a disciplinary hearing. Do any of the attendees want to speak about this agenda item? If so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of the screen and to alert commission staff. If you dialed into today's meeting, you may press *9 to raise your hand to alert commission staff. We'll need to wait a minute in the event that somebody wants to speak about this agenda item and is attempting to alert commission staff now. Will the commission executive officer please start a timer?
Yes. Commissioners, 1 minute has passed and we've received no requests to speak about this agenda item.
All right. Then hearing none, please, Commissioner Fletcher, if you could please continue with your report.
Thank you. In a connected circumstance, appellant 2024-036 P as in Paul, referred to here as employee, appealed an order of termination and charges removing him from the position of deputy sheriff, detention court services in the sheriff's office, known as department for this purpose. The commission appointed me, Commissioner Brian J. Fletcher, to hear the appeal and submit findings, conclusions, and recommendations to the Civil Service Commission. Thereafter, a hearing was held on February 27th and 28th, 2025. The causes of discipline were dishonesty, incompetency, and acts incompatible with and/or inimical to the public service. Findings of fact. The underlying facts of this case are the same as the previous decision I just read. For the sake of brevity, I will not repeat them. However, in this recitation of facts, reference to employee is to appellate 2024-36, P as in Paul, the officer we're referring to in this second situation. Reference to Deputy 1 is to appellate 2024-035P of the previous ruling. And reference to Deputy 2 is to Deputy 1 in the prior recitation. The remaining facts to be determined are: 1, whether the employee observed Deputy 1 use force against IP while in cell 14. 2, if so, did the employee fail to intervene in the physical altercation between Deputy 1, who is the employee in the previous report, and IP, and IP. 3, did the employee fail to report use of force on the part of Deputy 1? And 4, was the employee untruthful by failing to be fully forthcoming of his knowledge during his administrative interview? Based on the preponderance of the evidence presented to the hearing officer, the following facts are found to be true. 1, on April 10th, 2023, while working on the 7th floor of the SDCJ, the employee overheard a loud exchange of comments made between IP and Deputy 1 as they traversed from the staging back tower to the door to Module 7. At that point, as the cover deputy on the 7th floor, the employee joined Deputy 1, Deputy 2, whom he knew was being trained by Deputy 1, and the IP inside the door to the module, as IP was being readied for return to cell 14. 2, loud and aggressive comments and ramblings came from the IP nearly the entire time that he was present, as IP was unshackled, moved up to the stairs, and guided to cell 14. The employee also heard responses from Deputy 1, but could not recall what was said by either of them. 3, by the time the Deputy 1, Deputy 2, and IP entered cell 14, the employee was not in close enough proximity of the open cell door to observe any physical altercation involving IP, Deputy 1, or Deputy 2. Deputy 2 has testified, and the facts support that when the employee entered cell 14, Deputy 1 and IP were not involved in any physical struggle, and there was no use of force while the employee was in cell 14, but there was continued yelling and arguing between Deputy 1 and IP. The employee then interceded by tapping Deputy 1 on the shoulder and telling him to the effect, "All right, dude, we're good," then exited cell 4 approximately 10 seconds after entering, with Deputy 2 exiting immediately thereafter. 4, after IP, Deputy 1 and Deputy 2 entered cell 14, and for a period not more than 6 seconds, the employee was not in a position to observe activities occurring other than to hear the continued shouts exchanged between IP and Deputy 1. Over the next 7 seconds, the employee had a view into cell 14, but due to the presence of 3 adults, most of his view was obstructed by Deputy 2's body and the left shoulder of Deputy 1. After that period of observation, the deputy entered cell 14, tapping Deputy 1 on the shoulder and attempted to calm him down, assuring him that the arguing and encounter should end. Deputy 1 exited cell 14 approximately 11 seconds after the employee, and the employee closed the door to cell 14 approximately 3 seconds after Deputy 1 exited. Statements and testimony of Deputy 2 are consistent that he entered cell 14 once he observed Deputy 1 and IP in a physical struggle, which must have started immediately following their entry into the cell, just before Deputy 2 entered. There is no clear testimony from Deputy 2 just when he observed the 3 strikes to IP's head, but it is reasonable that these strikes came as Deputy 2 first entered and while he grabbed the IP's leg. This could have occurred during the first 6 seconds that Deputy 1 and IP entered, and the physical nature of the altercation ended before employee was outside the door to the cell. Neither Deputy 1 nor Deputy 2 informed the employee that the 2 of them were in a struggle with IP, and Deputy 1 used force in that struggle, and Deputy 1 used force in that struggle. As described in paragraphs 4 and 5 above, statements made to investigators and through the hearing on this matter support the employee's consistent responses that he never observed, nor was he aware of, the use of force that this hearing officer has already found occurred. Conclusions. Employee is not guilty of dishonesty. The department has failed to meet its burden of proving that the employee observed Deputy One's use of force in striking IP 3 times. Employee is guilty of incompetency. The employee is guilty of incompetency limited to the extent that he should have been more responsive to the conditions surrounding the handling of IP and should have been in a better position to intervene before use of force by Deputy One occurred. Employee is guilty of acts incompatible with and or inimical to the public service limited to a finding of incompetency as described in cause 2 above. This finding is mitigated by the fact that Deputy 1 and Deputy 2 were together in the transport of IP to cell 14. And there have been no aggressive movements by IP during the process justifying earlier intervention. But the constant verbal abuse should have warned the employee that such verbal abuse can reach a level where the recipient of the abuse might lash out. Level of discipline. The employee was not found to be dishonest, and that cause should not aggravate the contemplation of the level of discipline based on causes 2 and 3. As set forth herein, the employee's failure to be in a better position to intervene before Deputy 1 used force, in the light of all of verbal abuse by IP and arguing between the two of them, requires some level of discipline less than termination. Recommendations. Based on the findings and conclusions set forth above, I hereby recommend the following decision. 1, that the order of termination and charges be overturned, but that the employee shall be suspended without pay for a period of 30 work days. 2, that employee be awarded back pay, benefits, and interest from the date of removal to the date of this decision, minus wages attributable to the 30 workday suspension, and minus any wages, benefits, or other compensation employee received from other employment, unemployment benefits, or other assistance programs. And 3, that the proposed decision shall become effective upon the date of approval by the Civil Service Commission, and I so move.
Commissioner Johnson seconds.
All right, there's a motion by Commissioner Fletcher and a second by Commissioner Johnson. I'm going to go, okay, there it is, yeah. Thank you. Is there any discussion? All right, I will just point out in this case, I struggle with this one specifically because, first of all, I fail to understand what the point of this deputy was, if not to provide cover and overwatch for the deputies in the cell. So if the contention is that the deputy did not observe what happened in the cell, then what is the point of the deputy in that situation? I struggle with that. So saying that he is incompetent or he is guilty of incompetence as a result of that may very well be justified. But when the deputies are not vigilant, when they're not doing what is a very basic role of cover, there are 2 veterans on this commission, we understand that. People's lives are in danger. This situation could have easily escalated. Someone could have gotten really seriously hurt. So I don't know which way I'm going to vote on it, but I just want to point that out, that if the deputy does get off with a 30-day suspension and whatnot, that it needs to be communicated and on the record, as I am doing now, that this mistake was severe. It was a dangerous mistake. It could have caused someone to get seriously injured. And also the point of being there was to watch and to provide cover. So I do hope that regardless of the decision, that the deputy takes that into account and adjusts his behavior. Because I think I think I understand why the command wanted to move to termination. So hearing that, unless there's any response, I'll move on to the vote. Is there any response to that discussion? We're good?
Do you have any?
No comment.
Okay, there's no further comments. So seeing none, we will move, will the commission secretary please record commissioner votes?
Commissioner Fletcher,
Aye.
Commissioner Johnson.
Aye.
Commissioner Rodriguez Kennedy,
I'm going to vote nay. That passes with 2 commissioners in favor and 1 against, so it does carry. Commissioner Coleman is absent. We will now move to the next agenda item, which is the request for a Rule 4 liberty interest hearing regarding the failure of on probation for the position of Deputy Probation Officer by the Probation Department. Do any of the attendees want to speak about this agenda item? If so, and you joined the meeting using Zoom, please use the Q&A function on the bottom of your screen to alert commission staff. If you dialed into today's meeting, you may press *9 to raise your hand to alert commission staff. We will need to wait a minute in the event that somebody wants to speak about this agenda item and is attempting to alert commission staff now. Will the commission executive officer please start the timer?
Yes. Okay, we have David Lopez again requesting to speak on behalf of the appellant. Is anybody from the department out there that wants to speak to this matter as well? If you are from the probation department and you're here to speak about this matter, please raise your hand. Oh, okay, I see. Commissioners, we have David Lopez representing the appellant, and we have Shelley Frazier representing the probation department.
The timer is elapsed. Is the timer done?
Yeah, okay, well, yeah.
As a reminder, this employee is a peace officer. Please refer to the appellant as appellant or the case number we assign, 2025-010P. We will give the appellant's attorney an opportunity to speak first. Then we will allow the department's representative to respond. You will have up to 5 minutes each. Employee, you may now, or I guess it's an attorney, correct? The representative of the employee, you may now speak about the request.
Thank you. Good afternoon. This is David Lopez, attorney for appellant 2025 TAC 010P. We are seeking a liberty interest hearing for an ongoing administrative investigation. We understand that the appellant was released on as a probation failure. However, it's coincidental that the appellant was served a notice of investigation on December 7th of 2024, and then the probation failure notice was given to her and she was escorted out of probation on December 19th of 2024. The department states that the probation failure is separate from the administrative investigation, and as such, the appellant has no right to an appeal pursuant to Civil Service Rule 4.2.5. Had the administrative investigation been completed at the same time as the probation failure, appellant would have been afforded the opportunity for a liberty interest appeal. The department is currently prolonging the administrative investigation. I contacted the investigator today and was informed that the investigation is still ongoing and with no date as to when the appellant will have an opportunity to give a voluntary statement. If and when the investigation is finally completed, the appellant will not have an opportunity to appeal the findings. For one, she's not an employee any longer, and two, it's well past the 60-day filing requirements set forth in Civil Service Rule 4.2.5. And that is the reason for the filing of appellant's liberty interest request on February 18th of 2025 to meet the filing timeline. The opposition's argument is valid in that the investigation is incomplete and there may not be a liberty interest concern. But the fact that there is an ongoing investigation is detrimental to the appellant. Appellant wants to continue a career in law enforcement. However, the pending investigation is preventing her from moving past the initial application phase. She has been told on multiple occasions that because there's a pending investigation, she cannot continue on with any application process with another agency. In that, we ask for an opportunity to clear the appellant's name when the department finally completes the administrative investigation. If the commission finds that they're going to decline the liberty interest request, we would ask for an appeal, an opportunity to appeal this matter when probation department finally completes the administrative investigation. Please note that because there is this pending investigation against her and it could lead to a potential derogatory information being placed in her permanent file, she does have a constitutional right or a due process right to be able to speak on behalf of that and potentially clear her name of any sustained findings that are found against her in regards to the administrative investigation. With that, I yield to the commission. Thank you.
Mr. Lopez. Was it Lopez?
Yes, it was.
Then, do the commissioners have any questions for the appellant's attorney?
I do.
Commissioner Johnson?
Mr. Lopez, I think what you're trying to say in a nutshell is that the investigation maybe, we don't know, produce information that would be covered within the ambit of the liberty rights, but we don't know that yet. Excuse me. But we don't know that yet because the appeal isn't complete, or I'm sorry, the investigation isn't complete. However, you filed this request to preserve the time frame within which to do it. Is that
Yes.
right?
Yes, it
Okay.
is.
All right, thank you.
Any other questions of Mr. Lopez?
No, but I will reserve I will reserve the potential for questions after, in case I have any after the department makes their position.
I do
Here it
have
is.
one more question for Mr. Lopez.
Oh, Commissioner Johnson, go ahead.
Mr. Lopez, are you aware of any procedural mechanism that allows you to file this liberty request after the determination by the investigation?
No, I have not researched that, Commissioner.
So you're not sure whether or not there is or is not the ability to file such a request?
I am
After-
not aware. I'm sorry, I didn't mean to interrupt you. No, I
No,
am
that's
not
all
aware
right.
of any mechanism to
You knew what I
file.
was going to ask. Okay, thank you.
You're welcome.
Is there? Do we know?
Once you make your decision here, it's final.
It's final, meaning
So-
it cannot be revisited.
Cannot be revisited. He can, I suppose, take it to court.
Okay. So there's no, okay, I'll ask about that after let's hear the department and then I'll ask some procedural questions. Okay. Then now it is the opportunity, the department's opportunity to respond. For the record, will the department representative please state your name?
Good afternoon. My name is Shelley Frazier. I'm referring.
It is very difficult, Ms. Frazier, it is very difficult to hear you.
My apologies. Is this better?
It's much better.
Okay, thank you so much. Good afternoon, Commissioners. My name is Shelley Frazier. I'm representing the department in the case of 2025-0105. For the record, we are requesting to move forward with denying the request for the liberty interest hearing. The appellant's liberty interest was not violated. We used standard language in the dismissal letter, and the basis of the failure probation was due to not meeting it was performance-based, and she did not fulfill the duties of the position during her probationary period. I understand that they feel like we're damaging her reputation, but just to reiterate that the internal affairs investigation is separate from the performance-based failure. And in addition to that, it is currently ongoing. So we have not been in violation of Senate Bill 16, and the basis of the failure was not based on misconduct. So we're respectfully requesting that we do move forward and support the denial request for the liberty interest hearing. Thank you.
Do any of the commissioners have questions for Ms. Frazier?
That's what you're probably, okay, I understand.
Okay, I think,
I actually have the same question for the department as I had for Mr. Lopez, is, are you aware of any, my concern is that potentially the result of the investigation could result in information that falls within the ambit of a liberty request. And I understand that the timeline to file this was 60 days after the employment was terminated. However, the investigation is still ongoing, and the investigation may yield information that would have caused this to be maybe a good request. That remains to be seen. And my
So-
concern is considering this premature, is there a remedy or a mechanism to punt this and revisit it after we understand what the investigation result is and whether or not there would be public information about the result of the investigation?
So I believe that was a question to the department, then we'll figure out something else, but, Ms. Frazier, are you aware?
So, my understanding that the termination has nothing to do with the internal affairs investigation. The discharge sparks the liberty interest hearing, not the internal affairs investigation, so it's completely separate. This is solely on just the failure of probation, and it was based off her not meeting the duties of the position, not the IA. But
So
I'm
the
not,
IA investigation has nothing to do with the termination, is that right?
yes, that's correct.
And the result of the IA investigation, that would be confidential, correct?
Yes.
Did you answer?
Yeah, we didn't hear you.
Oh,
Said
my
yes.
apologies. Yes. Yes, Commissioner.
Wait, could you clarify? So you are saying that the result of the IA investigation,
My
Would-
apologies. My apologies. What I meant to say was if there was a possibility that there could be anything substantiated related to the Senate bill, then of course we would have to follow. But as far as the investigation, if there's no evidence of any of those allegations sustained, then there would be nothing in the file and nothing sustained on that, and that would be confidential. So to clear that up.
so I'm gonna clear it up. I'm gonna restate. So
Okay, thank you,
what
sir.
you are saying, from my understanding, is that if there are no sustained findings associated with this or relevant to the criteria posed by Senate Bill 16,
Mhm.
that it would be confidential. However, if there was a sustained finding relevant to one of those, I think, 8 criteria associated with Senate Bill 16, it would be something that is reported as is required by state law.
If it was one of them, if it was one of the 8, yes, then it would be something that we would have to post per Senate bill law.
Do you have another question, Commissioner Johnson?
No.
Commissioner Fletcher? Nope. For either side? Okay, so to go, so I believe our commission counsel would like to address the question, correct?
do you have
And
questions
we'll
for?
Oh, oh, you're available. Okay, all right, sorry. Now I understand. So do you have questions for commission counsel?
Morgan, you probably heard my concern. Do you have any, actually, I think my concern is cleared up by the department saying that the investigation had nothing to do with the failure of probation. Is that right?
That's
Yes,
the way I
that's-
understood it. I'm sorry, was that a question to me?
No,
Commissioner?
Ms. Frazier. I'm asking Ms. Frazier.
Yes, that's correct.
Okay, then I don't have any questions. Thanks, Morgan.
Okay. Then we will move on. All right.
Do we need to approve the,
No, I have to go. Move on to my script. Yeah, yeah.
I thought you meant.
No,
moving
no, no,
with
no, no.
With this gig.
No.
All right.
All right, so we have heard from the parties. Do any of the commissioners want to make a motion?
I'll move to approve the, or accept the, staff's recommendation.
Okay, is there a second?
Commissioner Fletcher seconds.
Any discussion? Then will the commission secretary please record commissioner votes?
Commissioner Fletcher,
Commissioner Fletcher will abstain.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy.
Aye. That passes with with 2 commissioners in favor, 1 commissioner abstaining, and with Commissioner Coleman absent. So that is a majority of those present and voting, so it carries. Right, that carries, right? We're good? Okay, just making sure. Okay. Okay, so we will move on to the next portion of the meeting, which is kind of a bummer. This is Commissioner Fletcher's last meeting with the Civil Service Commission, and we are sad to see him go. But we're also excited to work with our incoming commissioner, Commissioner Joseph Montenegro, whom we'll introduce at our next meeting. At this time, we'd like to take a few moments for commissioners and the executive officer to make some remarks to the outgoing Commissioner Fletcher and present him with a proclamation and plaque. So, Commission, oh, do you want me to start?
You can.
Oh, okay. Well, this I actually I always get like hate when the commissioners go. I mean, I really hated when Pete left last time, and I really appreciated working with you specifically, and also I also want to commend you because when you came onto this commission, frankly, and when I came on after, there were there was kind of a little bit of groupthink going on, and I think, and you know, this commission wasn't seen as a place where you could come on the employee side, in theory, and actually have like there was a view that there was like sort of a rubber stamping of decisions of the department side. And I think you were the first person through the door of like creating that equity of like, no, there's discussion happening. We're gonna look at these decisions, and we're gonna make a just decision based on on the facts or whatever. And it wasn't tied there. I think it started to break the mold of the idea that this was a rubber stamping body. And then I came on the board, and through that little crack that you opened up, I kicked it through the door and started arguing. But that was only possible because you were there. And so that is a meaningful contribution to the 19,000 employees of this county, to set the message and to create the standard that if there is something happening within our purview that you can bring to this commission will hear you. We're not just a rubber stamping body, and that was made possible first by your leadership through into the breach and opening the breach just enough so I could like kick the rest of the breach down, as Marines do. And I wanted to thank you for that because I would not have been able to do that without you, and I would not have done it had I not had the support of you in this position. So I want to thank you for your service. And I will pass on to whoever's next. Commissioner Johnson.
I'll go. Well, when I came onto the commission, I relieved you as the duty of being the newest commissioner, having been appointed. So in any event, I've grown to really, really appreciate you. I like you. I consider you to be a friend. You've been awesome on the on the commission, and we will miss you, and I will personally miss you. And I thank you for your service, and I'll be very brief, but I will miss you, and so will everybody on this commission.
Thank you.
Thanks, Brian.
And we'll move to the Commission Executive Officer.
Commissioner Fletcher, it has truly been a joy to work with you over the past 5 years. I think you've been one of the easiest commissioners to work with, a joy to work with. You're very readily available. That's what I mean. And I know that you've received some of the more complicated, difficult, and unusual cases. So thank you for all taking them and you know, putting all of your serious effort into those 8 cases, no matter how difficult they were, no matter how difficult it was to come out with an equitable decision, you did that very finely. And I think that in doing so, you truly have upheld the merit basis of the county's personnel system. On behalf of the Civil Service Commission, your colleagues on the commission and staff, I would like to present you with this plaque Of course, this plaque has a gavel because, you know, you do act like as a judge, as a hearing officer. And so this is in recognition of your 5 years of service. And and we can do it after we get, after the proclamation too.
All right. We do it this way. There we go. And there's a.
And then on behalf of Supervisor Monica Montgomery Stepp, she wants to present to you this proclamation honoring Brian Fletcher. Whereas county government includes standing and special citizen boards, commissions, committees, and task force formed to advise the Board of Supervisors and county staff on issues and policies and to serve as links to the community. And whereas Brian Fletcher has faithfully and diligently served on the Civil Service Commission as a San Diego County Civil Service Commissioner, twice as president and twice as vice president. And whereas during his 5+ years of serving on the San Diego County Civil Service Commission, Brian conducted many hearings and investigations, and his invaluable perspective resulted in significant contributions to personnel matters within the County of San Diego. And whereas Brian Fletcher continues to enhance San Diego County by serving as a community and international volunteer on the San Diego chapter of the Black American Political Associations of California, and continues to remain active in the community, donating his time, visiting local schools and hospitals, engaging in motivational discussions while sharing relevant life experience. Whereas in addition to serving on the Civil Service Commission, Brian J. Fletcher is a financial consultant, Wall Street veteran, National Football League veteran, and Super Bowl champion. Worked at the U.S. Embassy in Madrid, Spain, and worked internationally as a finance and operations consultant. And whereas Fletcher's experience have brought great insight and diversity to the County of San Diego throughout his service on the Civil Service Commission, and whereas the County of San Diego is committed to recognizing and honoring those individuals who are dedicated to the best ideals of public service, and Brian J. Fletcher is one such worthy citizen, now therefore be it proclaimed by Supervisor Montgomery Stepp on this second day of April 2025 that they commend Brian Fletcher for their continued service, leadership, and commitment to the citizens of San Diego County, and do hereby declare this day Brian Fletcher Day throughout San Diego County.
Yeah, wow. Wow. I never would have thought.
Brian Fletcher Day.
This is incredible. I don't want to get, I tear up easily, so I'm going to be brief. It has been an honor to be on the San Diego County Civil Service Commission. I never, before accepting this nomination, I never realized how consequential this commission is. And not only myself, but the current commissioners and prior commissioners that I've worked with have been incredibly impressed at how seriously they take the lives and situations that they judge each day. I want to start off. I was nominated to the commission by Supervisor Fletcher, and I do want to acknowledge that. I also want to move on and really thank Supervisor Montgomery for allowing me to finish my term. When she came in, I believe I had a year and a half or 2 years left on the term, and she had every right to want to nominate her own commissioner. And I really appreciate her allowing me to finish my term. And I obviously want to thank her for this proclamation. I never, even when I saw the frame, I never would have thought it would have read what it read. And I really appreciate your thoughtfulness, your kindness, Not only that, your service to the community, much over your time as supervisor, but um, the lifetime of service that you've given this city. I'd also like to thank the commissioners, the late Commissioner Ira Sharp. Um, he was a man of integrity, a man of integrity. They did a great job on this commission, did a great job in life. His commitment to the causes of San Diego, he is already missed. Commissioner Pete Smith, when I first came in, he was a senior member next to Ira Sharp, and he was incredible with his professionalism and links sort of to the decorum that um, of the past. And he was a really great bridge to from the past to commissioners come like myself and Commission President Rodriguez Kennedy and Commissioner Johnson. Kay, in her absence, Commissioner Coleman. In her absence, it's been a pleasure working with her for the short period of time, but she has been a pleasure. Very strong woman, and she's an inspiration. What she's going through and how she's dealing with it, and just her as a person. Melissa, Commissioner Johnson, I should say more formally. Um, has always lighthearted, always with the laugh, diehard football fan, incredible lawyer, just a pleasure to be around. And I've enjoyed every meeting, being able to um, to talk with her and be in her presence. You're not getting away with me, getting away from me yet.
I still need to see the purple ring.
Right. Commission President Rodriguez Kennedy, it has been a pleasure. I echo much of what you said about me in terms of sort of breaking a bit of a mold that we saw, and we did feel that there was a bit of um, conformity that probably needed to be shaken up a bit. Your presence, just like you said, gave me more confidence to speak my mind and to play devil's advocate and play the what if guy so that we can come out to the best decisions, sort of both ideals of the situation, really battling with facts to try to come up with the best conclusion. And I really appreciate you for that. Getting to the nuts and bolts, um, Executive Officer Todd Adams. Um, every year we're asked to do performance reviews for him, and it's almost laughable because I've never seen anyone so professional, so consistent, so on point in making this, along with his staff, as easy a job as possible considering the circumstances and letting us only have to concentrate on making a good decision and not all the other formalities. Uh, Commission Secretary Lisa Fitzpatrick, the motherly figure, she gets on me like a motherly figure. Always a pleasure. Another diehard football fan. I won't mention your team. I don't think they deserve to be to be a part of this, but she has been a pleasure to work with as well. Um, love the lighthearted banner as well, and what she brings to the commission on a daily basis. Uh, Commission analyst to Karen Bernardi, always, even in the room when discussions are happening, always positive, always additive, always um, makes the room smarter and more productive. Really appreciate what she brings to the commission as well. Commission Legal Advisor Morgan Foley, none but not least. Hopefully he's sitting down somewhere with his hip, but he has been fantastic in helping us as we battle ideas, keeping us within a legal framework so that we don't fall off the rails and make decisions that are outside of the scope of the commission or don't have a legal basis. Morgan has been steadfast. He's been here since I started, and he has been a steady presence on a ship that sometimes has been rocky with some of the cases that I've encountered. Last but not least, incoming commissioner Joe Montenegro. You are stepping into, I believe you fully understand it with your wife being a judge. But this is an incredibly consequential commission. It's not a ceremonial commission. It is one that has been given a good amount of power to be the final appellate body for San Diego County employees. And I wish you all the best. I'm very happy that you're here. I've heard nothing but good things about you. It's been a pleasure. It was a pleasure meeting you briefly earlier today. But I welcome you and I wish you the best of luck. Thank you. That's all that I have.
All right, well, we're getting at the end of the agenda, but so I just want to thank you again for your service. It's kind of cool saying that I served with the Super Bowl champion. Although who do we have to subpoena to get this ring?
I'll issue the subpoena right away.
But thank you. And we have now come to the agenda, the end of our agenda. So that concludes today's meeting. Thank you for attending. The next commission meeting is scheduled for March 7th, 2025. This meeting, I'm sorry.
May 7th.
It's March here though.
Yeah.
Okay,
does
just
say
making
March.
sure. I read it directly. So anyways, May 7th, 2025, this meeting is adjourned.
Thank you.